Good morning, everyone. My name is Dennis O'Connor, and I'm the commissioner assigned to the hearing this morning. We've got three cases that are combined. The first case is docket number FIC 2007-421. The second case is docket number FIC 2007-418, and the third one is docket number 2007-458, I believe it is. Let's see.
Yes. 458.
The date of this hearing is January 4th, 2008, and the time is 11:34. Seated at my left is an attorney for the commission, Tracy Brown, and she's going to kind of guide us along here and provide legal counsel as we need it. At this point in time, I will ask Tracy to explain to you the procedures we follow when we conduct hearings, so that you at least understand the process. And if you have any questions, you have an opportunity to raise them at this point in time relative to the process. Okay, with that, Tracy.
Okay, good morning. Tracy Brown from the Freedom of Information Commission. I'd just like to say at the start of the hearing, I have been part of the commission staff for about 11 years. During that time, the complainant was commissioner for the hearing. So, in other words, I used to work for him. But I would like to state also for the record that the adjudicator in this matter is not me. It is the Commissioner Dennis O'Connor, and you should have no fear that there will be any impartiality based upon the relationship. It was for a very limited time. With that, I'd like to explain, I think you both know the procedure, but I'm just going to do it for the record anyway. Based upon what transpires here today, the hearing officer will write a hearing officer's report. It will contain findings of fact and conclusions of law. That report will be submitted to the full commission. They meet typically every second and fourth Wednesday of every month. You'll get a copy of the hearing officer's report, attached to which will be the date on which that report will be before the full commission. You may come before the full commission to argue for or against that hearing officer's report. You'll be limited to legal argument at that time, so it's important that we get all the evidence on the record here today. To that end, we like to try to stipulate the document if we can. It is a time-saving measure if we can do it right. And what that means is the complainant will present any documents that he believes are material to the hearing officer hearing this case, show a copy of that to respondents. If there is an immediate agreement, I'll mark them, we'll get them into the record. If there is any hesitation at all, please just state that, and complainant will try to get them in the record in the formal manner. Same with the respondents. Any documents you have, you just show them to the other side. If there's any hesitation, just take it back, and we'll proceed under the formal manners to get it in. And with that, if there's nothing else, I'd like to try and start to do that. Okay, we'll go with, in the numerical order, docket number 2007-418. I've taken the liberty of making a few copies. I don't know if you've got copies already, of the documents that were submitted to the commission.
Actually, can I, excuse me, before we begin, I have one issue related to the hearing officer I'd like to bring forward, and then I have some other preliminary objections. Okay.
You want to state for the record who you are, though?
My name is Andy Tebow. Can you turn the tape on?
It's already
on. Oh,
on.
good. And I'm the complainant. And
before we proceed, I would ask that the complainant be sworn at this time.
Are you going to be giving testimony?
I don't have a problem with that as long as Attorney Cheney is sworn at the same time.
I'm here as an attorney, not as a witness, and I decline to be sworn. I'm not going to be offering any testimony.
Well, I have an issue with that, but I'll address that, and I'll be sworn in at any time.
Would you like to swear all the witnesses in at this time so that we could just do
Well,
that?
do you have a question relative to the process?
Yes, and I have several objections before the hearing starts.
I think we ought to swear you in then at this point in time.
Okay.
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 I'd like to swear all those who are going to be testifying today, so I can just do that once, please. Thank you. If everyone will stand and raise their right hands, do you solemnly swear that the testimony that you shall give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, thank you. Now, we'll start with you. Mr. Tebow, if you will please state your name, spell your last name, and affirm that you've taken the oath, and we'll go in order.
Thank you. Andy Tebow, Thibault.
And you've taken the oath.
Yes, I have taken the oath.
Okay, ma'am?
Jacqueline Manning, Manning, and I have taken the oath.
Okay, thank you. Here.
Paula Schwartz, SDH, and I have taken the oath.
Thank you. Sir?
David Lenihan, Lenihan, and I have taken the oath.
Okay. You can proceed.
Okay. And I'd like to state that I've never met the hearing officer before, and I've only done some preliminary inquiries. But I would ask, with respect to you personally and to your position, if you could please state any past or current relationships with the insurance industry, and whether any such relationships could impact your judgment or impartiality. The reason for this request is that a key component of the case hinges on the use of an insurance company or companies as beards or fronts to hide public records.
Just next.
Counsel
Next.
responding.
Pardon?
Your next point.
Well, that's it for the hearing officer.
Okay, and what's your next point?
Well, I'd like a response from the officer.
We'll take a short recess. I need to advise my client.
Okay, thank you.
Do you want us to clear the room, Attorney Brown?
No, we'll go on.
Yeah, no
It's easier
problem.
that way. We're back on the record.
I have no qualms about my impartiality in this matter. It's obviously a public record that I was an officer for an insurance company for many, many, many years, and I see no reason why the fact that I was an officer, I can't evaluate the situation objectively. That's what I intend to do. I will not recuse myself.
Thank you, and I wasn't asking you to
Yeah.
do that. I appreciate your candor,
Okay.
and I felt that it was my duty as a complainant to raise
That's
that
fine.
issue.
That's fine.
Thank you. Continuing, as you know or will learn from exhibits, Attorney Cheney has been intimately involved in my efforts to obtain documents from her clients. Now we have a situation where after my request for a subpoena, she had agreed to testify in this proceeding, and this is the first I heard that she would not be testifying. Now I don't pretend to understand all the legal issues, but according to the rules of professional conduct, there is an ethical issue for an attorney who represents a party in a proceeding
I object at this point.
in which she is
If
a
I-
witness.
if
I'm
there's an
sorry, he has an
objection pending.
objection pending.
With regard to whether or not my conduct in this matter prior to today or from today forward is ethical or not, is outside the scope of the jurisdiction of the commission, so I object to you hearing anything further about that point.
Do you want to give him leeway to finish his statement?
Yeah, why don't you finish the statement? That'll be
Okay,
fine.
I will note.
But I may have to rein you in if I think you're going.
Okay, well, I'll pay attention to you. The record shows that I did request a subpoena, which was denied, and in correspondence, Attorney Cheney said she would be a witness. So she knew or should have known that she would have been a witness in this matter for months. She's been the conduit for virtually all communication between myself and the respondents on all 3 FOI complaints. Therefore, I strongly object to her representing the respondents in the same matter in which she is an integral witness. She is not just a minor witness. Ms. Cheney and the respondents have already delayed the production of documents for months in these proceedings for their own selfish convenience.
Again, now I'm going to object.
Yeah,
This is really getting into testimony. because
Okay. Can you move it along, Mr. Thibodeau?
Well, it's Tebow. And
Thibodeau.
well, as a lay complainant, I'd like to know what the heck is up. I made a legitimate request for a subpoena. The FOI Commission has subpoena power. And then when Attorney Cheney wrote to the FOI Commission, I took her at her word on that matter. I don't know why I did, but she said she would be a witness. So what's up?
Well, she doesn't, she's representing counsel. It's her choice whether or not she wants to testify. It's unusual for counsel representing a respondent to testify.
I've
So,
determined that
yeah,
I can represent my client's interests without testifying.
And we do, I think, have a representative of the respondent here
We
who
actually
can
have two.
provide the information that we need, it seems to me, based on my review of the cases before us. There is a witness
Okay.
here.
All right, well, for the record, I'll remind, I'm disappointed that I didn't get the subpoena and that I get this late word that a witness I expected to be able to cross-examine is not a witness. For the record, I also remind Attorney Cheney that I intend to bring her illicit representation of the respondents and other
I'm gonna
matters
object at this
to the
point.
state and federal
Object.
grievance panels.
Object.
That goes to her code of professional
Again, I'm
responsibility.
going to object to that. That's really not properly before the commission. Thank you.
Okay. Well, so much for that part.
Okay, so now we're going to take whatever documentation you wish to offer us, starting with Mr. Tebow,
Okay.
relative to cases before us, starting with, I think we're starting with 418, which is your original complaint, I believe. Yeah.
As I started to say before, I took the liberty of making the photocopies of the attachments. As you may be aware, when you submit documents, when you file a complaint with the commission, the complaint letter is automatically a part of the evidentiary record. However, any attachments have to be marked separately as exhibits in order for them to become a part of the evidentiary record. And I have here a number of documents that I would like to show to Mr. Tebow. And if these are some of or all of the documents you wish to have entered into docket number 2007-418, please say so and just pass them to counsel.
Okay,
And if she
thanks.
has any objection, or hopefully, whatever, we'll proceed accordingly.
So these are some of the, as I understand it, these are some of the requests. I don't know if they're the complaints, but they're fine with me.
Okay, do you have any objection to those particular documents being entered into the record?
I'll have to review them if you just give me a moment.
Yes, of course.
That's really good. I did send that. This was your reply on the second. This was the Friday night, right? No, we have no objection to these documents.
Okay, thank you. I'm going to mark them now. I am marking a letter dated Wednesday, August 1st, 2007, to Superintendent Schwartz from Andy Tebow as Complainant's Exhibit A. I am marking as Complainant's Exhibit B a letter to Mr. Tebow from Christine Cheney, dated August 1st, 2007. I'm marking as Complainant's Exhibit C a letter to Superintendent Schwartz dated August 2nd, 2007, from Mr. Tebow. I'm marking as Complainant's Exhibit D a letter dated August 3rd, 2007, to Mr. Tebow from Christine Cheney. Complainant's Exhibit E is a copy of the letter dated August 3rd, 2007, to Superintendent Schwartz from Mr. T-Bolt. Are there any other documents that you'd like to have entered in for this docket number?
Yes. Now, I believe, correct me if I'm wrong, but I believe you did the requests. I'm not sure if you did the complaints. The requests are dated August 1, 3, 6. As I recall, complaints are August 3, 6, and 28.
If I might, just to make sure I understand, Ms. Attorney Brown, as I understand it, we are doing the cases seriatim, not all at once.
Right.
So the only complaint that would be relevant to the currently
That's
pending docket number is the August 3rd complaint?
That's right.
And that is a part of the record automatically, is
That's
it
already
not?
part of the record.
Thank you.
Yes. Did you file it?
Yeah, okay.
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 Okay, so,
So we're in effect doing 3 hearings in 90 minutes in terms of the order of business?
Hopefully we can do it in 90
complaints
minutes,
in 90
yeah,
minutes.
or less.
or less.
It's fine with me.
So are there any other documents you want to
Yes.
submit to the commission
I get a,
pertaining to your August 3rd complaint?
yes,
Okay.
I've got a write-in ballot that was
Just
ultimately
show it to
produced.
council, and if she doesn't object, I can mark it.
I would prefer if that either, I don't have a problem with this coming in so long as Mr. T-Bolt stipulates that he received all of these, not just this one.
Sure, I received them, not in a timely manner, but I
That's for
received all.
Mr. O'Connor to decide.
Well, that's what I'm saying to you.
But if you're willing to stipulate that you received all of the documents, regardless of the timing under which you
I
received them.
received a certain number, whether they were all of them, who knows? But I
Well, I
received,
think all you need to tell me is, why do you want us submit that at this point in time?
it's just an example of something that was produced that's still at issue, among the issues.
Well, actually, to the extent that this is being offered to demonstrate that a certain student won an election as opposed to another student, I don't think that actually does have any relevance to the hearing, to the issue before the hearing
So
officer.
you're objecting to it?
I am.
Okay, when we go back on record, you can reintroduce it, and I'll
Yeah.
make a ruling on it.
Want me to go through the rest of my pile?
Yes.
Okay. I have a bunch of correspondence.
Is this still for 418, right?
Pardon?
Is this still for docket number 418, or are these documents pertaining to your complaint and the other two?
Well, I didn't know if I was going to have to sort them out. S-
I think that's just about the write-in ballots.
I'll just talk about the write-in ballot now then, I guess.
Okay, hold on.
I'll hold the other stuff for later, the other exhibits.
I thought that the procedure was that it was pertinent to this docket number you wanted us to try to stipulate to.
Right.
That was my understanding.
Perhaps I am hearing that it might be easier for Mr. T-Bolt to present his documents as you give your testimony about each complaint.
Whatever you think. I mean, that's okay.
We could do it that way. The 418 is fairly straightforward, well, at least from looking at your letter complaint. However, when I get to 421, I'm having a problem. I don't see any formal request for information made by you, Mr. Tebow, to the respondent. So I'm wondering if 421 really isn't part and parcel of 418 for
Can't we just throw
purposes
them all in
of
the same
this.
soup and not...
Well, I don't want to get too far astray on any of these. I think the first two seem to be fairly close. The third one might be a little different. It's relative to the insurance policy in Massachusetts and representation by that law firm. But
It would be easier for Mr. Tebow to present 418 and 421 together
that's
and
what.
then do 458
Well, that's my
separately.
thinking on it. But what do you think?
We certainly don't object,
What do you
if
think?
that's what he would prefer to do.
Well, I really not hip to your tracking numbers. I just know I filed complaints at a certain
Yeah.
date.
Yeah.
And I didn't prepare 3 separate pieces of
Well,
testimony.
why don't we do it this way? I'll be the kind of the referee on this. Why don't you start with your first complaint on, when we get to it anyways. We'll proceed with 418. We have your letter of complaint to the FOI Commission of August 107. Number of items there that you were looking for from the respondents. And then we'll take it from there. But I want to try to track this in a logical fashion so that we come out with appropriate report on what our findings
Okay.
are. So.
Well, good luck.
Do you have any documents, since we've given the complainant an opportunity to try to stipulate to documents for 418, do you have anything other for 418?
I have testimony on 418, but no additional documents.
Okay.
Okay.
Do you have any documents for
I do.
any of them?
I do.
All right. For which documents?
I have a document that I think is most pertinent to 421.
Okay. Do you want to try to get that in now?
Sure. This is an affidavit. I'll give you the original. It's PDF'd, but it's the original. You can see
You could just give it
signed
to,
in blue.
yeah, show it to Mr. Tebow first, and then.
This is an email from Thomas Gerard.
The email, the affidavit is attached to the email. I brought
Okay.
included the email for completeness sake.
Thomas Gerard is over 18 years of age. I don't object to this.
Okay. I'll mark that as Respondents Exhibit 1 in docket number 418.
Can I get a copy of it later?
I have a copy of it for you.
Oh, you're so
So
nice.
I can turn this? Okay, thank
Let me
you.
just make sure, in light of the commissioner's desire to have this somewhat more orderly, I think this is probably more pertinent to 421.
421, you did say that, I'm sorry. So this is Respondents Exhibit 1 in docket number 2007-421. It's a multi-page document. It starts with a cover page, which is from T. Gerard, sent Thursday, January 3rd, 2008. And it includes the affidavit of Thomas Gerard dated January 3rd, 2008. Do you have anything else?
I do not.
Okay. Do you have any other documents you want to try to get in now, or do you want to present them as you're presenting your complaint?
Well, I'd like to give my testimony,
Okay.
and can I throw in the
And you can present the
exhibit for
exactly.
consideration
That's
after
right.
my testimony?
Actually, I would prefer that he offer them during his testimony. I know it's a technical point.
Well, I'd like to do it before or after, because I might lose my train of thought.
Oh, I see. That's fine then.
You know what I mean?
Okay.
Okay.
Is that all
As long as I
right?
have them
Yeah.
before.
Do you want it before or after?
Okay. After your testimony, you can try to get them in.
Okay.
Just before, yes. You won't be, not at the end, I don't think. you're
Right,
at the
I
end of
need
the-
Okay.
to have them before cross, that's all.
Okay, so I prepared my testimony, and I'd just like to go with it. Is that
Okay,
okay?
go right ahead.
Actually, if he's going to be reading from a document, of course, I'm entitled to a copy of it, and I'd like a
You
copy
can
of it.
listen now, and then we have it on tape anyway, so I think you need to give the complainant an opportunity to present his case. He's not an attorney, so we do grant him a little more leeway in terms of how he wants to proceed with his complaint. So go ahead, Mr. Tebow.
Thank you, sir. Thank you. I do appreciate very much the customary latitude given to all those who appear here, especially lay complainants. I'll make a brief opening statement and then recite the facts of the case. Besides myself, I will put forward one other witness, Jacqueline Manning. I come to this Freedom of Information Commission today full of hope for sunlight and justice. My hope stems from all those known and unknown, civil rights fighters and regular folks, who beat down the doors of illegitimate power so they could work an 8, 10, or 12-hour day and not be forced to shop at the company store or live in company dorms or shacks, from all those who suffered beatings and lynchings just to be able to vote, and certainly from all those who try to keep government open by prying loose public records from despots. We all know and must acknowledge that none of these rights were ever given to anyone. They had to be fought for and taken. Among those who gave me inspiration for this hearing is Harriet Hansen. Harriet Hansen was an 11-year-old Lowell, Mass. Girl working as a virtual slave in a textile mill in 1836. The era is quite familiar to the respondents, who have cited practices of the day, including whippings and beatings, as justification for some of their heinous practices in the regional District 10 government schools. A lawyer for the district even refers to students as inmates. Harriet Hansen knew prison-like conditions all too well. After working a 15-and-a-half-hour day, Harriet Hansen feasted on bread and gravy for supper and saw her wages cut and her boarding fee go up. She organized. She led a strike. Here are her words that so inspire me today. I worked in the lower room where I had heard the proposed strike fully, if not vehemently, discussed. I had been an ardent listener to what was said against this attempt at oppression on the part of the corporation, and naturally I took sides with the strikers. When the day came on which the girls were to turn out, those in the upper room started first, and so many of them left that our mill was at once shut down. Then, when the girls in my room stood irresolute, uncertain what to do, I, who began to think they would not go out after all their talk, became impatient and started on ahead, saying with childish bravado, "I don't care what you do. I'm going to turn out whether anyone else does or not." And I marched out and was followed by the others. As I look back at the long line that followed me, I was more proud than I have ever been since. Harriet Hansen went on to write a book called Loom and Spindle. She and her husband became steadfast supporters of women's suffrage. The spirit of Harriet Hansen is vital today as it was some 170 years ago when she stood up for justice. For we are brought here today by the actions of the respondents who stole an election and sought to cover it up. If not for the backbone and spirit of a few courageous students at Lewis Mills High School in Burlington, we never would have known of the police state tactics, including the withholding of public records by the respondents. This is all part of the backdrop of the famous Douche Bag case, Donninger v. Schwartz, Niehoff et al., and the election of a banned candidate to student office, Avery Donninger of Lewis Mills High School. The FOI Commission must set free all the documents sought in these requests and complaints of August 1, August 3, August 6, August 17 and 28, and a couple others in case I missed a few. The FOI Commission must begin to clean the stench and stains splattered on our students by the likes of Schwartz, Niehoff, and Cheney. This would be but one small step toward truth and justice. For even if all the waters of all the great oceans were channeled to cleanse and devour the remaining stigma, it could take a long time for the good students and faculty to recover and stand tall. Just as the mill owners of Lowell, Mass. Crushed little children into slave laborers, so too the despots of Region 10 seek to wipe out critical thinking and instill regimentation among a servile mass. Shine the light on these missing records, Mr. Hearing Officer. Hold these craven public officials accountable. Impose the maximum fines and civil penalties for these serial violators of the FOI law. Now to the requests and complaints beginning August 1, 2007. My August 1 request to Schwartz states, in addition, let me back up a second. I'll just note parenthetically, the FOI law demands that respondents produce in a timely manner the originals of all documents sought, in any case. Now again, my August 1 request to Schwartz states, in addition, this request covers copies of the write-in votes submitted from Ms. Donninger and any and all related records, including memos and emails. Memos and documents include, but are not limited to, discussions about the seizure of free speech T-shirts by your staff. To amplify, this request covers any and all public records about this matter in your possession or control, regardless of where they are stored, whether in your office, an office computer, home and home computer, etc. Cheney responded as follows to the write-in ballots. The board does not possess any copies of the write-in votes from Ms. Doninger or memos and emails regarding such write-in votes. There are also no documents or memos concerning the seizure of free speech T-shirts. Accordingly, the board will not be providing any documents in response to these requests. Again, I state the law demands prompt production of the originals in any such request. In response, I asked, what happened to the scores of write-in votes cast for Ms. Doninger? There were perhaps 100 such votes. Turned out there were much fewer, but did someone destroy these votes? Or are they hidden in some secret location? Who made the decision on what should be done with these documents? What discussions took place regarding these actions?
I'm going to have to make an objection. The document that Mr. Tebow is reading from is simply his letter of complaint. It's already in the record. If there's testimony with regard to what occurred here, I think that's appropriate. But for him to simply read documents that are already in the record, I don't think is an appropriate way to proceed.
Okay.
It's not a complete reading. I'm interspersing stuff in there.
I think that's what he's attempting to do, so I'm going to overrule that objection. And, see if we can get into the meat of the complaint,
Okay.
what records you asked for.
Anything that's redundant, I'll try to gloss over and say, I'll just summarize
Okay.
for expedience
Okay.
and proper form or whatever. So, no documents were produced in a timely manner regarding actually, no documents were produced regarding handling of the write-in votes and the storm of controversy and citizen outcry generated by the cancellation of the Battle of the Bands known as Jam Fest. In terms of the memories of Schwartz, Niehoff, and Cheney, I submit the following, and this goes to credibility. As a lawyer, Cheney should have discussed the deprivation of free speech rights of those voters who cast ballots for Avery Doninger.
Again, now I'm going to have to object. This is outside the scope.
Sustained.
Okay. As I told Schwartz, certainly there are records of who was on the ballot, who was taken off the ballot, who was solicited to run by the administration, and who, quote-unquote, won various elections without factoring in the write-in votes. I request those records as well. How did they know who to report as winners during announcements? I have no records of this. Was this communicated telepathically? Significantly, well, I think I'll gloss over some of this stuff. Well, okay. This goes to credibility as well. Cheney has attempted to rewrite history regarding the write-in ballots during another official proceeding.
Objection. My statements in another proceeding about my conduct as a professional has no relevance to this proceeding.
Okay, sustained.
Goes to her credibility. I'd like to bring in a document at
There's
this
been an
time.
objection.
Yeah, she's not a witness in this case.
But you
so-
should be.
Again, I'm going to object to any presentation with regard to this.
If I may make a suggestion, relative, we're doing 418 now and 421, maybe getting into 458 as well, but can we get zero in, Mr. Tebow, on precisely, I know what you asked for, precisely what you got and what you didn't get, and maybe that'll help us and help you as well focus in on this here. I don't believe you got all of the information or records you're looking for, but maybe you can.
Okay, the write-in ballots were not produced in a timely manner. They were produced about a week later after Cheney and Schwartz gave a false impression or lied about the existence of the write-in ballots.
But you did get the write-in, is that correct?
But not
they
in
were
a timely manner in compliance with the law.
Okay.
They have not produced a single, should I wait?
Go ahead. No. Go ahead.
They have not produced a single email or memo about the write-in ballots or any of the other related requests. They have not produced a single phone log. Indeed, they have not even produced a single email or phone log that was the subject of testimony by Schwartz and Lewis Mills principal Carissa Niehoff in U.S. District Court in August. Schwartz and Niehoff testified about a number of emails and phone calls received on April 25, 2007 regarding their cancellation of the Battle of the Bands known as Jam Fest. Now, they continue to hide the billing records ultimately paid for by the taxpayers in Burlington, Harwinton, and throughout all of Connecticut, using Cheney and the insurance carrier as beards or fronts. They have produced only portions of Cheney's billing records. I request again today, complete production of all unredacted billing records related to these matters for an in-camera review by the FOI Commission. It is unconscionable that Schwartz and Cheney should continue to stonewall and lie about the documents that should have been produced months ago. They should be fined.
And I'm going to have to object at this point. If the commissioner looks at the 3 complaints that are before him, they contain no information regarding a request for in-camera review of bills. That's a new request. It's
No,
not before you. It's not part of any of the
Well,
complaints.
that's incorrect.
What complaint is it a part of, Mr. Tebow?
Let's look at the exhibits.
No, it's got to be on the face of the complaint.
Just for the record, muddled in some of the documents that I have read several times in preparation for the 3 times we were supposed to hear this case, I have found, I do recall that there is a request for an in-camera inspection of the billing records.
Absolutely, but it's not the subject of any of the 3 complaints.
Yeah, it is.
Where?
My understanding from what Mr. Tebow is saying is he would like for the commission to do an in-camera review.
And I could
And,
submit the billing records
know.
she gave me to show how they're like gibberish.
New or old, I think the hearing officer is hearing a request for submission of the billing records.
We have no objection to such a request.
Okay.
Okay. Regarding the billing records, when a municipality selects lead counsel for serious and high-profile litigation, the administrators sign off one way or another on the selection of the firm to be hired. In any case, the board is a third-party beneficiary of the policy and the retainer. To date, documents citing the firm Howden Ludorf have not been produced. The Region 10 Board of Education should have been billed for and probably paid the deductible for the insurance policy related to this litigation. Where are those records? The public is paying directly and indirectly for Howden Ludorf's work. Clients, the taxpayers, have a right to view these records promptly during regular business hours. Perhaps Cheney continues to stonewall in production of these public records because they will demonstrate a massive lawyer welfare program funded unknowingly by taxpayers and insurance ratepayers.
There's an objection pending. I don't see that that is relevant to what he was provided and whether it was provided promptly.
I'm wrapping up here.
Okay.
It is also noteworthy that Cheney lied to a reporter for the Bristol Press, Jacqueline Manning, about the billing records.
I'm going to object. There's no relevance to this.
Okay. My final sentence in my testimony at this time is Manning wrote a number of stories about the case and reported a statement from Cheney that there was no retainer agreement with Howden Ludorf. And
Again, I'm going to object.
I'll produce my witness whenever you
Okay.
want. That's the end of my testimony.
Is that on just the first 2?
Well, maybe I'll think of something else, but I got
Well-
nothing else at this time.
Okay. Isn't it true, Mr. Tebow, that your former member...
First, his witness first on that.
I think I should...
She's going to give.
Okay. Yeah.
Do you have any... You said that you were going to present documents at the end of your testimony and ask that they be admitted. Do you
Oh,
have
you want me
those?
to do that now?
Yes, please.
Okay. Sorry, I forgot.
That's all right.
So I got this write-in ballot, and it's just offered as a public record, not for the substance of it.
I guess my question is, how is it relevant to your claim that you were or weren't provided documents and you were or weren't provided them promptly?
Okay.
Okay, we'll accept it. It goes to the weight anyway, so go ahead, we'll take that.
I could answer that, but whatever.
Do you have a copy for
Yeah,
us?
we can
Oh,
move it
no,
along.
You're supposed to do that. We'll get them at the end.
I'll get it
Okay.
at the end.
We can make
Sorry.
copies.
I'm going to mark this as complainant's exhibit F, with the exclusion of, are these your handwritten notes?
Yeah, you could, I could rip that off if you want.
No, we don't want to rip anything.
I don't object to... I assume that the commissioner can ignore the notes and just focus on the document.
Yeah, I'm going to put that on the record. To the exclusion of the handwritten notes by the complainant, Mr. Tebow, I have marked as complainant's exhibit F in docket number 2007-418, a copy of a one-page document that's captioned Class of 2008 ballot. Please circle the name of the candidate, and this lists some names and circles and stuff. Do you have any other documents you want to admit?
I'd like to admit my December 6th request for a subpoena of Attorney Cheney, and Cheney's response saying she would be a witness.
I object. No relevance to the
It's
issues.
filed as a public record at the FOI Commission.
It doesn't make it relevant to this proceeding.
Yes, it is a public record, but the issue of relevancy is different, and we'll let the hearing officer make the determination whether he's going to take that in or not.
For what purpose again, Mr. T?
It goes to credibility of the attorney and her witness.
I don't see how it goes to the credibility of my witness that I
Well, you're telling her what to say, and she's lying.
object to
Okay,
that, and I
I'll
ask that it be
sustain the
stricken.
objection.
Okay.
Comfortable with that?
Yes.
All right. I think that's it then, for my exhibits.
So this is the only other additional document, so if you want to proceed with your cross.
Thank you. Aren't you a former member of this commission, sir?
Yes.
What evidence do you have that there are documents regarding discussions about the seizure of T-shirts?
I don't have any evidence
Thank you.
that there were,
So the answer is none, correct?
if you say so.
No, I'm asking you. What evidence do you have that there are documents regarding discussions about seizure of T-shirts?
I don't have any at this time.
Okay. What documents do you maintain exist regarding the ballots that you did not receive, and what is your evidence that they exist?
My issue with the ballots is only the failure to produce them in a timely manner.
So you don't allege that there are any other documents that you were entitled to that exist that you didn't receive with regard to that?
I don't know.
Well, this is the time for the hearing,
I
so
have
you need...
no evidence at this time that any more exists than what you gave me.
Okay, thank you. What evidence do you have that there are email messages or memoranda about the ballots themselves?
I think there was a lot of email traffic around the cancellation of Jam Fest, some
Okay,
of which...
again, I'm going to ask that that answer be stricken. The question is not about, my question is a very specific one. What evidence do you have that there were email or memoranda exchanged within Region 10 regarding the ballots?
Well, let me back up a little, and I'll just tell you my thought process here.
Actually, I'm not interested in your thought process. I need to know what his evidence is. He's alleging that documents exist that he wasn't provided. I want to know the basis for that allegation.
I'll make
I
it
think
brief.
he's trying to
if he has
respond to it.
Yeah, his reason may be based upon his thought process. The commission will give that thought process whatever weight it's worth, so.
Thanks. The air is pretty light, right? But I had no evidence that write-in ballots existed, and I saw email traffic about issues related to these matters, so I suspect there's a lot of email traffic out there.
Okay, so that's the basis of your claim that there are emails you didn't receive, the notion that there's a lot of email traffic out there
About these issues.
about Jam Fest.
Time sensitive to Jam Fest, the seizure of the free speech T-shirts, and related matters.
Okay, so it's basically, your assertion is there must be.
I think it's highly likely.
Okay, thank you. That's all I need.
could go on.
What evidence do you have that there are phone log references that you're entitled, that you requested that you didn't receive? What evidence do you have that those exist?
Well, there was testimony in federal court about a lot of phone calls related to these matters, and I've received 0 phone log records.
So the fact that people had phone conversations, you think is evidence that phone logs exist? That's your theory. It's a yes or no question, sir.
Well, I'm trying to think about what you said. Can you repeat the question?
Sure. Your evidence to support your claim that phone logs exist that you weren't provided is the fact that people made telephone calls.
No.
So what is your evidence that phone logs exist that you weren't
Oh,
provided?
thanks for asking. I think the phone calls, it's public knowledge that the phone calls received by Schwartz drove her over to Brink and were,
I'm going to ask that that answer be stricken.
Okay.
or drove her near the Brink. She was very upset.
I'm going to ask that that answer be stricken. How is that indicative of there
Well,
being logged?
She kept a record of it so she could testify of how did she remember all these phone calls and who called. I mean,
So your
does
evidence...
she have like a photographic memory or something?
Well, since there isn't, in our view, anything to have been photographed by her memory, since there were no documents, the answer to that is most likely no.
I think it's been stated
gonna ask that
publicly
that
that
answer
there was
be
a certain
stricken.
number of phone calls
I don't
on or about
again.
April 25th.
So the answer to my question is, the fact that there were a number of phone calls is the evidence you have for the fact that there
No.
must be a log that you didn't get.
No.
Then what is your evidence for your claim
Thank you for
that phone
asking.
logs exist that you didn't receive? It's
There's
a-
been public statements by Schwartz, Niehoff, and others that they received a ton of phone calls on or about this date. More than 2 or 3, probably more than a dozen or a few dozen. How the heck did they keep track of them? Are they like mental wizards or something?
Okay. So your testimony is that there have been public statements by Ms. Schwartz and Ms. Niehoff that they got phone calls about ballots. Because that's what your request
Ballots,
was about.
cancellation of Jam Fest, free speech T-shirts.
Where in your complaint does it reference cancellation of Jam Fest?
I don't know. It's in there.
Show me where. Your request. When did you make this request, by the way, Mr. Tebow?
I began making requests around August 1st.
And when was the trial in this matter?
Around August, a few weeks later.
So their trial testimony can't be the basis of your complaint, because your complaint was filed on August 3rd prior to the trial. Isn't that right?
Well, you asked me what I thought, and I'd like to be able to respond to your question. What I thought my evidence was that there's phone logs or email traffic, and it's the public statements of your clients, which you're correct, came after I filed the complaint.
So when you filed your complaint, what was your basis for your claim that there were emails
I'm a
and
freaking
phone
psychic.
messages?
No,
Okay, thank you.
my years of experience
Thank
and
you, thank you.
intuition.
I think I have all I need on that. Mr. Tebow, you've read the affidavit of Mr. Gerard that I submitted.
Not
This
very well,
proceeding.
but I looked
Why
at
don't you
it.
take a closer look at it?
Jeez, I guess I have to.
I have a copy for him.
Do you have a
Oh.
copy?
Actually, I gave him a copy, but you can have another copy.
Oh,
if
boy.
misplaced.
It's better than Christmas. You know, this lawyer stuff, you gotta read carefully quite a few times. You know, I
If
might
I'm-
miss something.
I asked that that be stricken.
Okay, come on. Let's just trying to interject a little bit of humor here.
I won't ask that you be stricken.
I don't think that's a possibility, but you can go ahead and try.
Oh, no. I wouldn't wish that. I want you to stick around for a while.
Okay, let's try to get at the... let's-
Gerard's over 18, he's a lawyer. He's retained by Mastermind.
Now,
What?
why don't you just read it to yourself, and
Yeah.
I'm going to ask you a few questions about it. You don't need to read. I don't need you to read it aloud. I want you to review it, and then I'm going to ask you some questions.
Well, it's my learning device like phonics, you know? It sinks into me this way. So I don't need you
Just
helping me with it.
read it to yourself,
All right.
that'd be helpful, and
Okay.
I'll read it as well, so...
Okay. It's real poetry. Well, again, I'd have to read this a lot of times carefully, but I scanned it a couple times.
If you'd like a brief recess to review it more carefully, if you're concerned that you won't testify accurately, we can do that.
I'll testify accurately.
Okay. You had a chance to read the affidavit, Mr. Tebow?
I scanned it once or twice.
Okay. And you note, I'll just direct your attention first to paragraph 4. Now, you were present at the trial, right?
I was there for a majority of the hearing
And you
for an
know-
injunction.
Right. And you know who Thomas Gerard is, don't you?
Yeah, I met him.
And he presented the case in that proceeding, did he
That's
not?
correct.
I'll direct your attention first to paragraph 4.
Okay.
This is Mr. Gerard's sworn affidavit. It was given under oath.
Uh-huh.
Who does it say retained him?
Is that like a trick question?
No,
Right.
not at all.
Okay. Howden Ludorf was retained by Massamont Insurance Agency.
Right. Not Region 10, correct?
Well,
That's
who paid Massamont?
Again, the question is, by whom was Howden Ludorf retained?
The question is, this
No,
is a public record.
I get to decide what the question is
Yeah,
right
she
now.
does.
You're the decider?
Of this at this moment in time,
Okay.
as
You
to
just
what
have
the
to
question
respond
is.
to the question.
Oh, okay.
So Howden Ludorf was retained by Massamont Insurance, correct? That's what this says.
That's what your buddy said.
I asked, again, please. Who said that?
Tom Gerard, over 18.
That's right. And he's the partner in Howden Ludorf that handled the matter, isn't that right?
He's rolling in dough.
Again, please.
Yeah, come on.
All right, all right.
I'm not going to accept the side comments on that. We just keep this as professional as we can.
Okay.
Moving right forward. Council has the right to ask you a question and expect a direct answer.
All right, but, all right.
Okay, so Howden Ludorf, at least according to the sworn affidavit of a partner in that firm, Mr. Gerard, was retained by Massamont Insurance. Isn't that correct?
That's correct.
And if you look to paragraph 5, with whom does Howden Ludorf have a retainer agreement?
Has that question been asked and answered?
No, I'm asking you, if you look at paragraph 5, I'm asking you to read it, Mr. Tebow, and tell us what it says.
Howden Ludorf LLC has a retainer agreement with Massamont Insurance.
Right. That's correct. And then if you look at the second sentence in paragraph 5, what does that tell you?
I don't know.
It says Howden Ludorf has no retainer agreement, indemnification clause, retainer check, or any other check or invoice, or any other written agreement of any kind with Paula Schwartz, Carissa Niehoff, and/or the Board of Education for Region 10.
Okay,
Okay?
yeah,
So, according to Mr. Gerard, he was retained by Massamont, not by Region 10. His retainer agreement is with Massamont,
Yeah, okay.
not Region 10.
all right,
And he has no documents regarding his engagement
okay,
with Region 10,
yeah,
correct?
yeah, well, that's what it says.
Okay. And so Mr. Gerard is now lying under oath as well in his affidavit. Is
No,
that your
no, I
position?
never would think that of him.
Okay, so you have to assume this is accurate then.
I assume he wrote it.
Well, he
I
signed
don't
it.
disbelieve him.
Okay. And so you are not taking issue with the truth and accuracy of this affidavit?
I don't know, I mean,
I'm entitled to an answer to that question, and I claim it.
Either yes or no.
what?
I asked that, no, he's
Take issue?
testifying.
Well, based on the track record of you and the school district, I'd have to be skeptical.
Okay, so your position is that Attorney Gerard is also lying under oath?
I wouldn't say that.
Okay,
I only say that about you.
thank you. I ask that be stricken.
Okay.
I guess we're ruling on that.
But we need to, we need to, again, talk, are you through with this one, Counsel?
Yes, I am.
To have an admonishment, and
I am
it's
through.
for the complainant as well as his witness. Any of this off-the-record type comments have to be avoided. We know from reading your letters here that you have rather strong feelings about matters here, and I understand that. But we have to conduct this in an orderly manner, and
I'll
that's
try to
not
keep it in
happening
line.
now.
I hear what you're saying.
Otherwise, you're going to have to ask your witness who is talking to you, and we're going to have to ask her to go back there and sit, and
Okay, I understand.
if necessary, we'll take a recess
Yeah, okay.
till we get back on track
Yeah,
here.
well, it's on the track.
I have
So-
nothing further.
Okay. You might wish to readdress, Counsel crossed you, now you can readdress if you have anything you wish to.
Well, I would just state that the records in question are public records because they're paid for with taxpayer money, and that any citizen should be able to view these records without an appointment during normal business hours. The taxpayers are paying the insurance bill, the deductible, and they have a right to know how much these lawyers are being paid for this case.
Okay.
Okay. I think he has another witness.
Pardon me?
I believe.
That's right, you do have another witness down, you have a witness.
She's right here.
Proceed with that at this point.
Okay. I'll just grab some of my notes. Okay, my witness is Jacqueline Manning.
If I might, before we begin, any documents that Ms. Manning has in front of her, I'm entitled to review, so.
I don't have any documents in front of me.
Actually,
They're all Andy's. It's just a notepad.
And those are notes as well that I would be entitled to review.
Good. Well, there you go. Happy reading.
If I could ask again, please admonish the complainant and his witness to conduct themselves appropriately.
Okay.
Should I ask her what her name is? Or you already know?
You already told me it was
Okay,
Jacqueline.
okay. Okay, Ms. Manning, you were a reporter for the Bristol Press,
Yes.
and you covered the events surrounding Jam Fests, seizure of free speech T-shirts, suppressed election at Lewis Mills High School.
Yes.
And during this time when a federal civil rights trial came up, you spoke with Attorney Christine Cheney and Attorney Thomas Gerard regarding their work on that case and their legal bills.
Yes.
Could you just tell us about your conversations with Attorney Cheney and Attorney Gerard when you asked about the funding source for their work and for the retainer agreement?
Well, first I attempted to make a phone call to Thomas Gerard. He did not return my phone call. And I attempted to call Attorney Christine Cheney. She did not return my phone call in regards to my questioning as to how Howden Ludorf came to be involved in the defense of Paula Schwartz and Carissa Niehoff. I also placed a phone call to Katie Rule, who was co-counsel with Thomas Gerard from Howden Ludorf, and she did not return my phone call. Let's see, on August 9th, I was on my way to pick up the copies of the write-in ballots from Andy Tebow, and I had put in a call to Christine Cheney and also to Thomas Gerard. He did not return my phone call again. I wanted to know, again, how they came to be involved in the defense. This time, Attorney Christine Cheney did call me back. I remember I pulled off onto the side of the road at Johnny Cake Airport on my way into Torrington, and I asked her about the retainer agreement between Howden Ludorf and Region 10. She said that none existed. She said it was a private matter. And I said, it's certainly not a private matter if taxpayers' dollars are paying for this, and I plan to submit an FOI request to retain this information, to obtain this information. She told me that if I did submit an FOI request, I was going to receive the same answer that Mr. Tebow was, that there is no retainer agreement in existence between Howden Ludorf and Region 10. I said to her, well, what about billing records? Are there any billing records? And she said there are no copies or records of bills sent from Howden Ludorf to Region 10, nor are there any payments of receipt from Region 10 to Howden Ludorf for their services. And so my natural response was, so they're not getting paid. And she said, I didn't say that. So I'm like, okay. And that was, we might have said a few more things, but that was the gist of the conversation. So at that time, I decided to write the article based on the election ballots that were suppressed. So, and I kept my notes. And then a few days later, Andy Thibault called me, and he directed me to the rules of professional responsibility, which is that a retainer agreement must exist between a client and between an attorney and their client. And I ended up to call Chief Disciplinary Counsel of the Connecticut Judicial Branch, Mark Dubois. I confirmed with him. I said, is it against the legal ethics for an attorney to, for a client to retain an attorney without a retainer agreement? He said it absolutely was, and I took some comments for him for the record. After speaking with Chief Disciplinary Counsel Mark Dubois, I put in a phone call to Thomas Gerard. I left him a message saying basically that I had spoken with Mr. Dubois, and that he said that Christine Chinney had told me there was no retainer agreement between Howden Ludorf and Region 10. And that was a violation of the professional code of ethics, and I welcomed his comments and anything that he had to say for this article. I also put in a call to Christine Chinney, and basically, I don't remember the exact message I left, but it was I would like to ask you a few questions about the, I can't remember exactly what I said to her, but I do remember that for the sake of simplicity, because of the way that this whole hiding behind the insurance company and saying, oh, well, it's not Region 10. However, that insurance company is paid by Region 10 taxpayers' dollars, and they are affiliated with the Board of Ed and a third party to that. So basically, I left a message for Paula Schwartz on her answering machine, which was this: are the taxpayers of Harwington and Burlington paying for the services of Howden Ludorf in any way, shape, or form? She never returned my phone call, Mrs. Schwartz. Thomas Gerard had called me back a few hours later to comment, and he said, absolutely, Mark Dubois is completely right. We do have a retainer agreement. Our retainer agreement is with Mass Amount Insurance Company. They are the insurance carrier for Region 10 Board of Education. I said, thank you very much, Mr. Gerard. He told me that that insurance company was paying all their bills, their legal services. Christine Chinney called me back. I remembered I was right around deadline, but it would extend deadline, and when she called me back, it was a few hours later. And I asked her again if there was any retainer agreement between Howden Ludorf and Region 10, and she said no. And I said, are there any records of bills in existence? That is, bills paid out to Howden Ludorf or bills sent by Howden Ludorf to Region 10. And she said, I thought we covered this to some effect. I don't remember her exact words. She goes, where are you going with this? I said, let me boil it down to a simple question. Are the taxpayers of Harwington and Burlington paying for the services of Howden Ludorf in any way, shape, or form? And she said no. And I said, thank you very much, Attorney Cheney. And I went to go hang up the phone, and I hear, wait. So I said yes, and she said, well, the Howden Ludorf has a retainer agreement with Region 10's insurance company, but I don't really know that I want to go on the record as saying that. And I said, well, Attorney Chinney, what do you want to go on the record as saying? She says, I'm really not comfortable going on the record saying anything. I said, well, I put in a call to you, basically, and I put in a call to everyone else, so do you want me to write no comment, or would you prefer that I used your comments that you gave me last time, that this was a private matter? And she said, yeah, I guess that would be fine. She didn't want to comment on the fact that it was actually the insurance company that had the retainer agreement with Howden Ludorf. She did not want to go on the paper saying that, and I did not put it in the article because she asked me not to.
Another question. You wrote about this in one or more stories, one of which was dated August 17,
yes,
2007 in the Bristol Press. And in your conversations with Attorney Chinney, what were the limits or extent of your question? Did you say, was there any retainer agreement? Or did you get a response?
I'm going to object at this point. This proceeding is about what documents exist and what documents don't exist and what documents were provided. This witness has in no way indicated that there's a retainer agreement between Howden Ludorf and Region 10, and I think whatever she wrote about that in an article is irrelevant.
Well, we're looking for any documentation of payments for the insurance company that pays the lawyers. And there was a deductible that apparently was paid, but we haven't received a record of that. In any case, taxpayers' money is at stake here. The public has a right to know, and that's the basis of this element of the case. So I believe she should be allowed to answer.
Unless this witness is going to testify that she has evidence that a deductible had already been paid at the time one of the complaints was filed, I see no relevance to it.
I see a huge relevance to it because Region 10 pays mass amount insurance.
Yeah, I think I'm going to allow the witness to continue with her testimony.
Thank you.
With respect to that.
Should I repeat the
And we'll
question?
weigh the, it all goes to the weight anyways.
Thank you. Now, when you, in your early conversations with Attorney Cheney regarding any retainer agreement, what in her responses led you to call Mark Dubois the Chief Disciplinary Counsel?
Actually, it was you who called me and said, you know, according to the Professional Code of Ethics, Rules Section 1.5.
Yeah, but what about her answers? What were your early questions to her?
Oh, that
What
she
were
said
her
that there was no retainer agreement between Howden Ludorf and Region 10. And so, then faced with, I'm sorry, go ahead.
Let me follow. Did she say there was no retainer agreement at all without respect to Region 10 or the Man in the Moon?
Objection, relevant.
Okay.
The only thing that's relevant is whether there's a retainer agreement between the public agency and Howden Ludorf. If there's a third party, it's quite,
May I
it's the
address
commission.
that?
The commission's rulings have been quite clear with regard to that. There's the most recently in Susan Neep versus Mayor of the Town of East Hartford. Relationships between counsel and insurance companies that it's not a relationship between counsel and the public agency. The commission has been quite clear about that.
May I address that point? The core issue here is the use of taxpayer money, which is in some manner funneled to pay these lawyers. Now, if an insurance company is in effect acting as a public agency or a front or a beard, it's all relevant, and I urge the commission to explore that issue in terms of any prior decisions or from this moment forward, what's right and wrong about following the flow of taxpayer money.
Again, the commission is not about following the flow of taxpayer money. It's about access to documents that exist and have been requested and access to public meetings.
Let me state.
With regard to the issue of retainer agreements, the commission has specifically and repeatedly ruled that a relationship between an insurance carrier and an insurance company does not create a public record simply by virtue of that existence of that relationship. So unless there's evidence that this witness can present that Region 10 possessed a copy of the documents that exist between Howden Ludorf and Massamount or the bills that were submitted by Howden Ludorf to Massamount, there's no relevance.
The relevance is that you cannot have an expenditure of public or taxpayer money without a public record being generated.
Exactly.
Again, that's neither here nor there.
I believe that the commissioner has the point that you've been trying to make.
Okay, yeah, we're cool.
So.
Did that nicely. Okay, at this point in time, I think I'm going to take a recess.
We'll come back for you to close examine.
About 10 minutes, and then you can continue.
And your witnesses, of course, would, yes.
Okay?
All right.
Okay.
Thank you.
Thank you.
Okay, we're back on the record after a recess.
Okay.
Okay.
Mr. Tebow, I believe you were presenting your witness.
I think we finished our testimony, right?
I think so, yeah.
So we're all set.
Really. And
Yes.
Do you have, okay, where are we going now?
Cross-examination,
And
if she has
you
any.
finished with your cross, or are you going to do
I
it cross?
haven't started it.
Okay, okay.
No.
No, I don't think that's necessary, unless the commissioner would prefer.
I can't hear you, I'm sorry.
She's asking if she needs to change seats with Mr. Tebow. My
Oh,
understanding
you
is
can
not.
stay right there. Yeah.
Do you know the difference between an insurance premium, a deductible, and a retainer? It's a yes or no question?
Yes.
Okay. What's an insurance premium?
I object. Her knowledge of insurance isn't relevant to them withholding public records.
To the best of your knowledge, you could answer the questions that...
Yes, an insurance premium is a certain amount that the insurance company charges their client for whatever services they're providing as far as insurance coverage goes. That's a yearly bill, broken up and paid in however many installments. What was the other?
What's a deductible?
Oh, the deductible is the certain amount that's paid out before the insurance company will start to kick in their part of the agreement.
And what is a retainer?
The retainer agreement is a binding legal agreement between two parties,
Between two parties?
or three,
Really?
actually.
I'm going to show you the affidavit of Mr. Gerard. Have you had an opportunity to review that?
I saw it briefly, but
Why don't you review it carefully?
Might I interject? We don't dispute anything that's in the affidavit.
yes, I'm not.
The issue is,
I'm asking this witness about the affidavit. I'm entitled to do so.
okay.
Yes. I'd ask that you read the entire affidavit, and then I'm going to ask you some questions about it. There's no question before you at this time.
Is there a highlighter?
You can't really mark, well, that's not the exhibit itself, I don't know.
This is a
You
copy?
could underline.
I just asked you that you read it, and then I'm going to ask you some questions
can I
about
make
it.
some
I prefer
notations?
that you not make notations on it, no.
Okay, should just answer them to the best of your knowledge. If you don't know the answer, you can just tell I don't know. And I realize there's a lot there to read.
Yeah, there is, and that's why I want to take my time.
Might help you, counsel, if you, in your questions, refer to specific paragraphs, and maybe you intend to do that, which would make it easier for the witness. Excuse me.
Okay. Is there anything in that affidavit that differs with what you testified Attorney Gerard told you?
That differs with what Attorney Gerard told me?
That's correct.
Well, Attorney Gerard did not tell me that Howden Ludorf was retained by Mass Amount Insurance Agency. That's as to number 4, paragraph 4.
Let me ask the question again. Is there anything in this affidavit that is contrary to what Attorney Gerard told you? If there's more in the affidavit than what he told you, I'm not interested in that.
Okay.
Is there something here that is about what you spoke to about him with that's different from what he told you? That's what I want to know.
Okay. No.
Thank you. Just one other question. What evidence do you have that there was a deductible paid by Region 10 to Mass Amount Insurance Company prior to the date of the filing of Mr. T-Bolt's complaints in this matter?
I don't.
Thank you. No further questions.
May I make a notation of an observancy? Okay.
If that's okay.
If I might, I would ask that it be limited to the scope of the cross at this point. This hearing's already lasted quite a long time.
Yes.
Up with the cross.
Is there anything in the affidavit that differs from what Attorney Cheney told you?
Objection, beyond the scope of cross.
I didn't think it was, but
I didn't ask her about
Well,
her
she's
conversations
already
with me.
testified to that, there's nothing different in it.
no, I mean from what Attorney Cheney said.
And that was not a part of my
No,
cross.
it wasn't part of it.
It just seems to me that
Objection is pending.
Oh, I'm sorry.
I ask that the objection be sustained. It's beyond the scope of cross.
Sustained.
You can't say anything unless somebody asks you a question. That's allowed. So, based on what Attorney Cheney asked you, did you have anything else to add?
Objection. I object to her testifying in narrative. She's been doing question
Well,
and
do you
answer up
want
to now.
Hey, she asked me to carefully read this document. She asked me to sit here and actually carefully read through this document.
Right.
And I've noticed something in here that I'd really like to put on the record.
Okay, you have a problem with your previous testimony, you can do that.
If it's only if it goes to your previous answers not being accurate. I asked you specific questions on cross, and unless you're going to
The
change your
hearing
answer.
officer makes the ruling, not you.
Yeah,
I'm
I'm going to
make-
allow her to testify. I understand what you're saying. Go ahead and just, if you got to
It just,
clarify something.
yes, it's
that's what you're trying to
clarification
do,
here.
that's
It's
fine.
just clarification here. For paragraph number 5, it says, Howden Ludorf LLC has a retainer agreement with Mass Amount Insurance in connection with its representation of Paula Schwartz, Carissa Niehoff, and Regional 10 School District in the federal court action Doninger, PPA, Doninger v. Niehoff, case number, you know the case number. So it says that they have a retainer agreement with Mass Amount in connection with the representation of Paula Schwartz, Carissa Niehoff, and Regional School 10, and the Regional 10 School District. And then in a very opposite statement just following that, it says Howden Ludorf has no retainer agreement, indemnification clause, retainer check, or any other invoice or any other written agreement of any kind with Paula Schwartz, Carissa Niehoff, and the Board of Education for Regional 10 School District 10 regarding Howden Ludorf LLC's representation of Paula Schwartz, Carissa Niehoff, and Regional 10 School District in the federal court action of Doninger PPA, Doninger v. Niehoff, case number. It doesn't make any sense.
Okay,
It's a complete contradiction.
Document speaks for itself.
yeah.
And moreover, I think
Yes, and I wanted to say paragraph 5 definitely speaks for itself as well. Those two statements.
absolutely.
Yes.
They're both true, they're both accurate, they're both sworn. I have no
don't have
further
anything
questions for this
Okay.
witness.
Do you have no further questions?
I have no further questions for this
Okay.
witness. no.
Okay.
Okay. And then you're done with this witness as well?
Yes.
All right, I'm going to have to ask you, if
Yep.
you wouldn't mind taking a seat back there for us, please. Thank you. With that, counsel, you can proceed with your defense.
Thank you. The first witness is Paula Schwartz. Mrs. Schwartz, by whom are you employed?
Major North School District number 10.
And for how many years have you held that position?
A little under 5 years.
You recall receiving an initial FOI request from the complainant on about August 1st?
I received a fax, an email, and eventually a letter that was mailed, regular mail.
And I'm just going to show you a document, and bear with me since I don't have...
If you don't mind, if you could speak a bit louder.
Sure.
I think it might help.
I'm going to show...
On this side of the table.
I'm going to show Mrs. Schwartz what's been marked as Complainant Exhibit A.
Yeah.
Do you recall receiving that?
This was the fax that was sent.
And he also sent you an email and left you a voicemail on that day?
That's correct.
Where were you on August 1st?
August 1st, Dave Lenahan, the business manager, and I left the office around 10 o'clock to go to Glastonbury for a bonding, to get a bond, finance bond on our building project. And we were gone pretty much all afternoon.
Where were you just prior to August 1st?
As I typically do, I have a vacation and return to work on that Monday, July 30th was my first day of work. I was gone for about 2.5 weeks.
Did you try to contact Mr. Thibault when you received these multiple requests on August 1st?
I did. I left him a voice message.
And do you recall when that was?
It was either on the 1st or the first thing on the 2nd. It probably was on the 1st, late in the afternoon.
And do you recall the substance of the message you left for him?
That I had his request, and I would, to the best of my ability, get him. He was asking for a lot of documents and items that I would have to, it would take me a little bit of time to get it, but that he would get them in a timely fashion.
And did there come a time when you referred Mr. Thibault's requests to me?
On this, I guess when I received, on the 2nd, I received another email, another letter, and another fax, and a phone message demanding the documents. I called you.
Why did you ask me to respond to Mr. Thibault's requests from that point on rather than responding yourself?
Well, there are a couple of reasons. One, it was just the volume of the request and the tone of the letters really had me concerned. I had just gotten back from vacation. We were extremely busy beginning. I had found out about this lawsuit when I came back on the 30th, so there were a lot of things that needed to be done. And I thought they were related, and it was a good idea to call you. That's why I have counsel.
Excuse me, do you mind if I grab my briefcase? I'm sorry to interrupt you.
I do
left
mind,
some
actually.
documents.
I'd like to proceed with my direct at this time. I don't, that's actually, I strike that. That's fine.
Thank you. Thank you. Sorry to interrupt you.
But you're not going to be making a whole lot of commotion with the papers.
I'll sit
and
still.
stuff.
Oh, with your briefcase, I
All right,
guess.
yeah, okay.
You gonna open it now?
Yeah.
We'll take care of the little noise. Okay.
Sorry.
Proceed.
At the time that you received this request from Mr. Thibault, as well as the ones in the same very brief time frame about the ballots, did you know whether there were copies of the ballots?
No, I didn't.
So were there, did you know whether there were originals of the ballots?
No, I didn't know specifically when I first got whether they were the ballots, where the ballots were, or if there were ballots at this point.
But you did tell me there were no copies of the ballots.
There were
and
no
you knew
copies
that.
of the ballots that I was aware of.
And you thought his request was for copies of the ballots.
That's correct.
Was there, besides the fact that you had just returned from vacation, you were at the bonding hearing in Glastonbury, and you were preparing to defend yourself in a federal lawsuit, were there any other circumstances that are relevant that the hearing officer should hear regarding the difficulty you might have had producing documents at that time?
Well, our building has been undergoing a $51 million renovation project, and beginning in May of that year, the school year, we had to vacate the administrative offices. That was about 20 people, had to be relocated. And we only took what we considered essential items. It was the summer, it was a quiet time. Things were put in storage. We were all scattered around the middle school library complex. I had a little office. My secretary shared a space with 4 or 5 other people, so there were very limited records available.
And in addition to yourself and the secretarial staff, who else was dislocated from central office at that time?
All of special education, all of the business office functions, buildings and grounds, the assistant superintendent, the director of language arts, and all of the secretarial staff that supports all of those people.
So all of those people were out of their regular places?
That's correct.
And they did not have all of the documents that they would normally have?
Correct.
Ready to hand?
That's correct.
What about the high school? Where was the high school office located during the summer of 2007?
Much the same as our staff is the smallest staff, but they were all relocated to the nurse's office, and everything in their office was also put into storage in another area.
Now, did you subsequently learn that Principal Niehoff had kept the ballots?
Well, the first that I don't know if, I'm not even sure Carissa was there at that point. She may have been. Different people were on vacation in the summer. I don't remember.
And
I
who is
remember
Carissa, by the way?
Carissa is the principal of the high school. I asked if in fact they did retain the ballots, because typically in a high school election, you have the election, you get rid of the ballots. I mean, it's not a formal thing in that sense. So they seem to remember that they had them, they didn't know where they were. And I believe they eventually did find them.
And once you knew that they were found, you then contacted me and let me know that.
That is correct.
But,
And then,
initially you had told me there were no copies, and as far as you knew, perhaps no ballots at all.
exactly. The request came in on a Wednesday, August 1st.
And do you remember approximately when the ballots were found?
They were found probably the beginning of the next week. It may have been that the administrator in charge knew where the box was, and they found the box. I know that I called Mr. Thibault and invited him to come in to see. His first request was simply for write-in ballots, and that I wasn't really sure that those existed, because I didn't know how that happened. If people wrote, I didn't see the ballots when they were done, so I
As
didn't know.
superintendent of schools, would you typically be involved with an election for high school officers?
No, that would certainly be beyond my realm of responsibility at that level.
Once you found the ballots, did you contact Mr. Thibault?
I did.
And did you invite him to come in and view the ballots?
I did, and in fact, I took it upon myself to sit with him, to show him, to give him the write-in ballots. He came in with Mr. Brewer, another gentleman who I didn't know, and we sat in the open area of the library, and I gave him the write-in ballots. And I made copies of them, and then and he signed off on it, paid me for them, and that was it.
And those were the write-in ballots?
That was the write-in ballots.
Now, at that time, did he make an additional request to you about ballots?
Yeah, when he was sitting with me, he asked me if he could get copies of all the ballots.
And were you able to give those to him immediately?
My secretary, we made copies of it, and I believe later on in that, remember that the request was on August 1st, and I believe it was like August 7th, somewhere around there. I wasn't I'm not sure I gave them to him or my secretary did, because we had, to compound matters further, there was a death of a student. You may have remembered there was a...
Now,
okay.
when was, about when in the course of all this did the student pass away?
It was during that week, and I don't remember the specific date. The problem was, there was a graduate, a June 2007 graduate. He was on vacation in North Carolina, and he was killed in a water jet ski accident. And so I had to deal with that. So whether I gave him the ballots or my secretary, one of us definitely gave him the ballots. I have a signed receipt that he received them.
Bottom line, did the complainant receive all of the ballots within a week or so of his request?
Yes.
By the end of the following week?
By the end of the following
He
week.
received not only the write-in ballots, which was his initial request, but the additional ballots.
That
that
was-
he
What
had
date did he
subsequently-
receive them? I asked that question. I don't know.
I think it was
All of them.
the 8th? The 9th? Yeah, the 7th was when I gave him the write-in ballots, and the 9th was when he got all of the ballots.
And were all of the ballots the subject of his initial request, as you understood it?
No, it was only the write-in ballot, the write-in votes.
And then on the 9th, he got all ballots.
That's correct.
As of August 1st, 2007, did the board have any billing records related to legal work performed by Howden Ludorf LLC regarding the Avery Doninger matter?
No, we did not.
Have you ever received such documents?
I have never received any of those documents.
To the best of your knowledge, has any of your staff received copies of bills from Howden Ludorf for their work on the Avery Doninger matter?
No, no one's received any bills.
As of August 1st, did the board have any billing records related to legal work performed by Chinny and Muser LLC regarding the Avery Doninger matter?
No, I did not.
As of August 1st, did the board have any of the following documents concerning Howden Ludorf in connection with any alleged civil rights violations by you against, or by Ms. Niehoff, or by any member of your staff, against Avery Doninger or any other student, any of the following? Did you have a retainer agreement with Howden Ludorf regarding that?
No, we did not have a retainer agreement.
An indemnification clause?
We did not have an indemnification clause.
A retainer check?
We did not have a retainer check.
Any other check or invoice?
No, we did not.
A
No,
bill for a deductible?
no bill for a deductible.
Are you aware of any agreement between Howden Ludorf and an insurance company?
I don't know personally of that agreement.
Do you possess a copy of it now?
No,
Have you ever possessed a copy of
no,
it?
I've never.
Have you ever seen it?
No,
As of August 1st, did the board have any of the following documents concerning Chinny and Muser in connection with any civil rights violations by you, by Ms. Niehoff, or by any member of your staff against Avery Doninger or any other student? Any of the following? A retainer agreement?
no retainer agreement.
An indemnification clause?
No indemnification
A
clause.
retainer check?
No retainer check.
Any other check or invoice?
None.
When did Region 10 engage Chinny and Muser?
We engaged you in March of 2006.
For the Doninger matter?
No, as general counsel,
On all matters.
on all matters.
And has there been any change in that engagement since that date?
No, none.
Any change in engagement in connection with the Doninger matter?
No,
As of August 1st, 2007, did you possess a copy of papers removing the Doninger lawsuit from state to federal court?
no, I had no.
As of August 1st, 2007, did you possess a copy of an appearance filed by me in the federal court matter?
No, I did not.
Did the complainant subsequently request documents pertaining to the board's insurance coverage?
They did.
And what did you do with that request?
I passed them along to Dave Lanahan, my business manager.
And do you know whether Mr. Lenahan addressed those issues?
Yes, he did.
You heard the testimony of Ms. Manning that she called you she left a message for you regarding retainers, deductibles, and so forth. Did you hear that testimony today?
I did hear the testimony.
Do you recall receiving such a phone message from Ms. Manning?
I do not. I do not remember a phone call with Ms. Manning. She has called me on other matters, but I don't remember specifically on this one.
You don't remember getting that message?
No.
I have no further questions, subject to redirect.
The council, the cross council.
Yes, please. Mrs. Schwartz, on August 1, after you received the email fax, do you recall getting a couple of phone messages from me?
Yes.
And you stated that you called me back, and do you remember what you said, more or less?
That I would get you whatever documents I had available, and it would take me a little bit of time to dig up some of the other ones.
Okay. And you left this message on my cell phone or some other phone?
I assume it was your cell phone.
Yeah, okay. Do you recall saying your request will be processed in due time within our reasonableness? You can't expect us to put it all together within the hour of your call. We will do it in a timely manner, okay? If you need to speak with me, you can certainly call me back.
Well, I don't have a photographic memory or memory at my age. I have no idea exactly the words that I used, so I can't verify that that's what I said. What I would normally say to any FOI request is I will get it to you as soon as I can, whatever's available,
Okay.
and we will get you the rest of the information when we can.
Do you recall receiving another message from me on August 2, Thursday?
There were numerous phone calls. I believe there was another one on August 2nd. That's correct.
Did you return that call?
I'm sure either I did or I passed it on to Chris. I don't remember at what point.
Okay. Do you recall getting a copy of a fax sent by Attorney Chinney to me on August 2nd?
Yes.
Okay. All right. Do you recall speaking with me on Friday, August 3rd, around 10:45 a.m.?
Maybe if you remind me of the nature of the call, I might remember
Thank you.
what.
I'll be happy to do that. The call followed the, the prior interactions we just discussed and you testified to. And then I filed a complaint on Friday morning and followed up with a phone call as I followed up my request with phone calls. I asked you whether, on Friday morning, around 10:45, this is, again, Friday, August 3rd, I called you and asked you whether you might have any documents available for inspection following my requests of Wednesday and Thursday. Do you remember that conversation?
There probably was another phone call.
Okay.
That's all I can remember.
If the witness doesn't recall, she doesn't recall.
Okay,
Right.
well,
I do remember seeing the filing of the complaint.
okay.
August 1st was the request that was made. August 3rd was the filing.
Okay, that's right, and that's important because after I filed the
I'm
complaint,
going to object at this point. Now he's testifying. He's supposed to be questioning at this point. He's had his chance to testify.
she asked me to refresh her memory on the
But
conversation.
that phone call's been
Okay,
addressed.
come on. Go ahead, continue.
Thank you. When I asked you for documents, any documents, if any documents might be available for inspection that morning, Friday, August 3rd at 10:45 a.m., do you recall saying certainly not?
I don't remember having that conversation.
Do you
or using
recall
those words.
me telling you that's not acceptable?
You were very insistent that you wanted what you wanted, and I didn't necessarily have those documents available at that point in time. You asked for a lot of things.
Okay. When you spoke in response to questions by Attorney Cheney about the ballots, the public records of the ballots, and you said regarding the student election, it's not a formal thing in that sense in terms of preservation of the public records. What did you mean?
Objection. This commission has no jurisdiction over record retention.
I don't think it's a matter of record retention. She testified what she did with the ballots or what her knowledge of the ballots were, and that's all your question, I believe, is related to her testimony here.
Understanding, I have no objection.
Okay.
Well, regarding record production, when you said regarding the ballots and the student election, it's not a formal thing in that sense, what did you mean?
Normally, we have elections, we announce the winners, that's it. What happens to the records, there's no formal process.
Who announced the winners?
I have no idea.
And how did they know, if there were no written records, who won the election?
I object at this point. It's beyond the scope of direct. It also has no relevance to this proceeding.
Well, I think it does to some extent. Go ahead with the question. I'm going to allow it.
Among the items I requested were records of who was on the ballot, who the administration candidates were, and who won and who got how many votes. How did the person who made the announcements of who won know?
They had the ballots.
So they...
I would assume they had the ballots, they count them, they have piles, they know what the numbers are of who won. I wasn't there, I don't know how it was formally done.
So you're saying you believe somebody counted the ballots to
Yeah,
figure out
that's
who
the way
won?
they are done, yes.
And then they read from a list?
I don't know. I can't answer that question for
Does
you.
such a list exist?
Not as far as I know the list existed.
When you said you were not involved in the election, what do you mean by that?
I don't set the candidates, I don't talk to the candidates. It's a function of the high school procedure. I don't get involved
You
in
stated you were
elections.
not involved. Are you stating you were not involved in this particular election?
I object.
That's not the question. You were asking me if I'm involved in elections. The election process goes forward.
You stated, excuse me,
Stay on your side, please.
Okay. You stated in response to Attorney Cheney that you're not involved in student elections. Are you saying you were not involved in this particular election, or has your memory been jogged as to how you might have been involved?
I'm going to object again on the basis of relevance.
It's regarding the production of the ballots.
Again.
Well, phrase your question differently then. Why don't you just come right out and ask, were you involved? That's what your question is.
Were you involved, and if so, how, in this particular election?
I assume what you're asking me is for the election, the ballots, the kids voting, the counting of the ballots. I was not involved in that process. As it pertained to the lawsuit, I certainly am involved in the process in terms of that, but certainly not in terms of the election.
Well, on or about the time of the election, was that, what, April or May? Around May, perhaps?
Again, I'm going to, this is really just seeking discovery for
She
the
opened the
federal
door.
lawsuit. I didn't open the door. He didn't ask any I did not ask her any questions other than, my questions went to why she didn't immediately know where the ballots were.
And
She answered she wasn't involved.
If I may state to the hearing officer, the superintendent stated she was not involved in elections, and I tried to pursue that, perhaps not so artfully in terms of her credibility. So I can't figure out what to ask next, so I'll shut up on that.
Okay.
Let's see. Who approved Howden Ludorf as counsel for the Region 10 school system, yourself and Principal Niehoff?
I have no idea.
When did you first learn that Howden Ludorf were your lawyers?
I think we received a letter. I think Dave, the business manager, received a letter saying that the insurance company was going to take on the case, and I'm not sure if the letter itself had their name in it. David may have better recollection than I have.
Had you or the business manager inquired to see if the insurance company would cover representation by Howden Ludorf?
No, that we file when there's pending litigation, we notify our insurance company. That's our responsibility, and then they take it from there.
So you're saying you had no role in the selection of Howden Ludorf as your counsel?
That's correct.
And who wrote the letter that said you had coverage for Howden Ludorf? You said you received the letter.
Objection, mischaracterization of the testimony. What she testified to was that they received a letter from the insurance company saying they accepted coverage. That's all she testified to.
The question is who signed the letter? Is that
Yeah, what was the source of the letter? Who wrote it?
I don't remember off the top of my head who wrote the letter.
My question, perhaps more properly, should be, was this letter from the insurance company or from Attorney Cheney, or?
No, my recollection letterhead was from Massamont Insurance.
What's the approximate cost of your insurance policy?
Objection, relevance.
It's among the public records sought.
It's among the public records sought in receipt.
I think she answered. She has no idea anyway. So.
Oh, okay.
You know.
All right. Well, I have nothing else for Mrs. Schwartz.
Okay.
I could just have a moment. I have no questions from this. I have no further questions from Mrs. Schwartz either.
We have an additional witness.
I do have one other witness. Hopefully we can be brief. Called David Lenahan.
Yes.
Mr. Lenahan, by whom are you employed?
Regional School District Number 10.
And in what position?
I serve as the business manager.
How long have you been the business manager in Region 10?
Almost 8 years.
How did you come to be involved in the respondents responding to the complainant's FOI requests?
There was a FOI request that came to Superintendent Paula Schwartz that involved a request for insurance policies, invoices paid, and she passed it on to me.
And if you know, why did she pass it on to you?
One of the things I'm responsible for is expenditures as well as insurance.
I'm going to show you a document and ask you if you can identify it. Do you recognize that document?
Yes, I do. It's the request with respect to several things, including Massamount insurance information.
This has not been marked because this actually goes to 458, so you probably want to mark it at this point.
I don't object.
Which one is that? I'm sorry.
This is, if you look at the 458 paperwork, it's the document, it's the last document that's written by Mr. Tebold in that packet. I can tell you for sure. I'll show it to Mr. Tebold too to make sure he agrees.
Thanks. That's fine.
That's the same as that one.
You want that marked?
I don't much care if it's a complainant's exhibit, respondent's
Oh, I
exhibit,
don't
or a
care.
joint exhibit.
about a
I just
joint
think
exhibit?
I just think it should be in.
Change the face,
Yeah, fine with me.
Joint Exhibit 1 and docket number 458 is a one-page letter dated August 17th, 2007 to Superintendent Scorch from Mr. Tebow.
So just for the record, Ms. Flanagan, and then, actually, if you could just have one, and then I
Yeah,
just
just wondering.
keep track of
Okay. Yeah.
the documents. So that's joint one, is that what we're calling this? And what actions did you take in responding to joint one?
Following this request, I had a copy made of a letter that I had received from Massamount Insurance Company, and it was provided to Mr. Tebow, I believe on that same day, August 17th. And he came in, I believe he paid for the per copy page, and he got the document.
Was there any difficulty in providing this document and some of the other documents at that time for you?
Well, as I think Superintendent Schwartz has testified to, we were going through an office relocation at the time, so that my normal office, including my secretary and all the bookkeepers, had been relocated, and we had come only with a minimum of files, so that, yes, some of these files were in storage and were not readily available.
But you gave him the letter from Massachusetts, you believe, that day?
Yes, that happened to be a very current letter. I believe it was, you know, dated either late July or early August.
Was there any, did you speak with Mr. Thibault, or did you simply contact him by letter?
I spoke with Mr. Thibault on I believe, some other requests. One of the things he had also asked in the FOI request was copies of insurance policies and related invoices to the insurance company.
And what did you tell Mr. Thibault about those documents?
Well, at the time, I had copies of our 0607, fiscal year 0607 policies, as well as the total payments that we had made for the 0607 year. In a conversation with Mr. Thibault, I believe I indicated that this was an old policy. It was not the policy that was in effect starting July 1. My recollection is he initially said, you know, well, maybe I really don't want it, and then I think throughout the conversation he said, you know what, it would provide a baseline for me, so I will take it. So we had those documents prepared and copied, and he also came in and picked them up after paying the you know, the fee for those copies.
Is there any document that Mr. Thibault requested that you didn't have?
Yes, I told him, I believe in that same conversation, or it might have been some other correspondence, that the 0708, which was effective July 1st, policies with respect to this matter were not available. That is not unusual for most insurance policies. They're not readily available in the beginning of the term. And I told him, I believe or maybe it was a letter from you to him that indicated that as soon as I found out and received those policies, I would let him know about it.
And did you subsequently contact him about that?
Yes, as soon as I got them, I sent him a letter, I think it was on or about November 1st, indicating that the policies were available and that the fee would be payable, and we would provide him with the copies.
And what did you hear any response from Mr. Thibault?
I believe Mr. Thibault then sent a letter to Superintendent Paula Schwartz, among other things, referencing the policy document, and I believe he asked if he could review the document rather than have a copy. And Mr. Schwartz made that, brought that to my attention. I then sent him another letter indicating that, yes, he could come in and review the copy, and I asked him to just let me know when he could do that.
And have you heard from him since?
He then called me, left me a message, thanked me for the correspondence. I believe he said something, I'll be back in touch, and I never heard anything subsequent to that.
As business manager, you handled bills in the district, do you not?
I do.
Have you ever received any copy of any bill Howden Ludorf has sent to Massamount in the Doninger matter or any other matter?
No.
Do you now, or have you ever possessed a copy of any retainer agreement between Howden Ludorf and Massamount Insurance Company?
No.
Have you ever seen such a document?
No.
Is there, to the best of your knowledge, a retainer agreement between Howden Ludorf and Regional School District Number 10?
There is not.
Has Howden Ludorf sent any bills to Regional School District 10 at any time during your tenure as business manager?
They have not.
So no bills at all from Howden Ludorf for the past 8 or so years?
That is correct.
Had you paid, is there a deductible under the Massamount insurance policy?
Yes.
Had you paid that deductible as of the date of Mr. Thibault's request, August 17th, 2007?
No.
Did you subsequently pay that deductible?
Well, all insurance policies have deductibles, so that you don't necessarily pay them in any given year unless you have a claim. We have deductibles under all of our policies as well as premiums, and subsequently, I believe in October, we received a bill from Massamount for the deductible on that policy.
And did you pay that bill?
I did.
And have you received a request from Mr. T-Bolt for that bill or for the payment by Region 10?
No.
No further questions.
I only have a couple brief questions, but I'll ask Attorney Cheney if she could stipulate with me that Mr. Lanahan is responsive, professional, friendly, and even kind enough to show guests where the bathroom is.
I'd be happy to stipulate to that, Mr. T-Bolt. Thank you for saying it.
Okay.
That was no easy feat because we were under construction, so I had to find a bathroom that was open.
Now, just a couple quick
Sure.
questions. Has Massamount been, how long have you been the business manager?
8 years.
During that time, has Massamount been your carrier?
No, not for those whole 8 years, no.
When did Massamount become your carrier?
July 1st,
Of this year?
yes.
Well, that's always tricky at the beginning of the year.
Yeah.
2007?
Yes.
Right. Just want the record to be clear.
Do you recall the approximate cost of the prior carrier policy and
Well,
this one?
Okay, I'm going
We-
to object at this point. I don't see the relevance to the provision of records, what the relative cost of the two is.
I'm sorry, I was just wondering, to know, what was that question again?
I asked if he recalled the approximate cost of the prior policy versus the new policy with Massamount.
And for what purpose are you asking that question?
Well, I guess I gotta admit it's not responsive to production of records or relevant, so I'll withdraw that question. So you stated fairly in the past few months you've paid the deductible,
Yes.
and was that about $5,000?
Yes. Exactly 5,000.
Okay. So, actually, the cost is relevant in terms of taxpayer money and public records. What is the cost of the current policy?
Objection, relevance. This proceeding is about the provision of documents or not. And that Freedom of Information Commission has jurisdiction only over those matters.
Let me just think about the question for a
Sure.
moment, if I may.
Go ahead.
You stated that the deductible was paid and it was about $5,000. That was nice of you to answer that question. Is there any compelling reason why you wouldn't answer the similar question?
Objection, relevance.
I'm going to allow the question.
What's the approximate cost of the Massamount policy?
Well, there's several policies that cover Region 10, the largest one being property liability. I don't have the exact numbers in front of me, but that legal liability policy that you're referring to, the premium is about $2,300 a year.
And do you expect that to go up?
No.
Okay. Well, thank you very much.
Okay.
Okay. Go ahead.
Counsel, do you want to redirect based upon his?
No.
Okay. And I think you might be the best person because you're probably most familiar with the policy and the clauses in it as the superintendent.
Actually, well, what's your question?
My question
I'm not an
is-
insurance expert.
Right. Do you have any understanding based upon the clauses in the policy that the district has any right to request documents from us?
I'm not aware of that, no.
Have you ever tried to ask for documents from them pertaining
No.
to your coverage?
No, I have not.
Okay. That's it.
I have nothing further.
Just
Do you have any
one-
questions? I think you might have additional questions, do you?
Oh, I'm
You
sorry,
want-
did
sure.
the Commissioner have any questions for Mr. Lanahan?
No, no.
I do have a few other questions. The Superintendent, thank you. The complainant has made a number of requests, well, mingled in his request, he seems to be asking for meeting minutes. In one request, he does specifically state from Howard and Rudolph regarding the Doniger civil rights lawsuit. But in other requests, mingled among the 3 complaints that we have here, he does ask for meeting minutes pertaining to how the administration handled the matter, and I'm assuming the Doniger matter. Did the board go into, conduct any meetings wherein it dealt with the Doniger matter? And would there be any meetings reflecting those discussions?
The Board of Education?
Yes. Is that a part of the administration as?
What, I'm not sure, whenever we have pending litigation, I alert the board to those kinds of matters.
And is that in a memo form? Or do
It
you
wouldn't
just
be,
make
it
a
would be
full call?
it would probably be an executive session, we'd talk about it.
So did you go into executive session with respect to this matter with the board? And are there any minutes that reflect that you went into executive session to talk about this
No, we don't,
lawsuit?
we leave the board out of those.
Okay.
Even, they know that there's a pending matter of a lawsuit was filed, and that's all that they are given.
Spare me just for a second. So I can find it specifically. I'm looking at my little cheat sheet instead. Okay, I have another question. With respect to the billing records from Cheney and, how do you pronounce your?
Muser.
Muser, LLC. The complainant alleges in one of his letters of complaint that he didn't receive all of the bills and that some of them were redacted, and he's requesting unredacted bills. There was no testimony with respect to that, so I don't know if you want
There actually was. I had asked her if, as of the date that he made that request, the only request that's the subject of the complaint, because we have to go off the face of the complaint. As of August 1st, did they have any documents from me with regard to work on that matter? And the answer is no. We did provide him with bills from January to June, and those were redacted. And if the commission is now directing us to provide unredacted copies for in-camera review, we will certainly do so.
That was my request, and I
that-
can try to find the initial request on paper if you want, if that's necessary.
I don't know that it is.
I don't believe that it is.
Yeah.
Okay.
And if, I mean, I would be happy to provide copies of the bills that have already been provided to the complainant in redacted form, unredacted to the commission for in-camera review. We can certainly do that. We weren't directed to do that for today's proceeding, so that wasn't my understanding. And would you agree that that
That is
wasn't
correct.
something you
It wasn't.
request? So we would be happy to do that if that's something the commission would like us to do, of course.
I don't know.
That's my request.
You want unredacted?
Yes, and as Attorney Cheney stated, she provided redacted from January to June.
Correct.
And do you recall also stating that you would provide July at some point?
I'm not under ooth, and I'm not going to testify.
Oh, okay, well, I didn't mean
But-
Trying to clarify, I think.
But if he would like,
what you would
put it this
stipulate
way,
to.
if Mr.
Okay, some of the-
Tebow would like bills for additional periods, we are more than happy to provide them.
As I recall, I have in my notes that his request was dated August 2nd, 2007, and I believe he asked for the billing records from January 1st, 2007 to present.
Right, and at that time, as Ms. Schwartz testified,
You only-
we'd only billed through June.
Okay.
We would be happy to provide Mr. Tebow for August forward as
About-
part of this process if you'd like.
How about the calendar year, January to December?
No,
Well-
I think we're only going to be dealing with whatever bills that were generated
Right.
between January 1 and August 2nd as they might exist
Okay.
now.
And so what I will not provide obviously, in
Well, we would like to see a copy of what you redacted and
course.
the documents unredacted, so I think that we would request that they be provided, and Cameron, you and I can talk about when.
Sure.
You have that ready.
So you want January through June 2007 bills unredacted for in-camera review?
Yes.
No problem.
Okay. And I believe we did take testimony that the respondents do not have any records related to the hiring of Howard and Ludorf.
Yes.
You didn't hire them. That was the testimony, okay. All right. And we've gone around a little bit regarding meeting minutes, memos, phone logs, and emails regarding the administration's handling of the Doniger and Schwartz-Niehoff matter.
Actually, that was going to be a follow-up question I had to your questions that I was
Okay.
going to ask her on redirect, but if you want to go and ask it yourself
Yep.
now.
Go ahead.
Did you keep any minutes of any meetings that occurred between yourself and Ms. Niehoff, or yourself and any other member of your administrative staff regarding the handling of the Doniger matter? Minutes of meetings.
No, there are no minutes to meetings.
Did you write any emails to Ms. Niehoff or any other members of your staff regarding the handling of this matter?
I got to think about that. There were emails with you.
Those would be,
Yeah,
that's not
that's-
this,
Yeah.
not between you and your
No.
staff. That's all that I was
That's
asking about. And you don't possess any phone logs regarding, phone calls regarding the Doniger matter?
No.
Do you have any records at all, other beyond what might be already have been provided to Mr. Tebow relative to the Doninger matter that would be covered in his
This request?
request?
I don't know.
Okay. I don't have any more either. I think,
Can I redirect?
yeah, you may redirect,
Thank you.
of course.
Mrs. Schwartz, you stated in response to a question by Attorney Cheney that you would words to the effect that you might routinely inform the board if there was pending litigation or whatever.
Actually,
Coming
I believe for the record that was in response to a question by Attorney Brown.
Touche. Oops, I slipped on your side.
Okay, what's your
Okay,
question?
as long as you don't kick me.
I won't. Do you recall in other sworn testimony that you admitted discussing the Doniger matter in executive session prior to the litigation?
Objection, relevance. That was-
Credibility.
No, that wasn't her question.
Well, she said that she discussed the Doniger matter in terms of pending litigation, as if she was doing things properly. So I'm asking her, do you remember testifying under oath that you admitted and other board members admitted discussing the Doniger matter in executive session prior to litigation?
And again, I'm gonna object. That's pertinent to another complaint by another party that we've not yet heard a ruling on
What
from
goes
the
to
commission.
credibility here?
Doesn't go to credibility here. There's been no ruling on
What
that
is your,
issue.
what are you trying to get at?
That on certain occasions, the superintendent is not telling the truth.
Okay, well, what about this occasion?
I was going to bring up a contradiction.
I don't see the relevance of that. She asked whether she'd informed the board in executive session about the pending litigation. The answer was no. There is another complaint before the commission that has yet to be determined where another complainant alleges that the matter was discussed in executive session prior to the litigation in an executive session convened for another purpose. We don't have a ruling on the commission from that yet. I don't see the relevance of that to this proceeding.
I'm going to sustain the objection.
Okay. Is it possible for me to recall witness Manning for one question?
What's the question?
The question is, can you elaborate on your testimony about talking to Superintendent Schwartz about the deductible and her response?
I would object.
How does that help the commission
yeah.
determine that? No.
No, you can't.
Okay.
I think we got a pretty good handle on
Okay,
that
sure.
issue.
Okay.
Just have
I have
one.
nothing else then, except to sum up.
Probably have some final instructions for you. Okay.
I think that document should be admitted just for, I think the hearing officer's going to need that.
I agree. I have no objection. That can be joint too, as
Okay,
far as
sure.
I'm concerned.
Joint number 2.
Thank you.
I'm
I'm
not joint also, but I guess it is also joint number 2, isn't it?
This will be Joint Exhibit Number 2 and docket number 2007-458. It is a single-page document, but it's printed on 2 sides. It's dated August 17th, 2007, to Mr. T-Balt from Attorney Cheney. Okay.
At this point, we're going to be closing the hearing, but you do, if you'd like, have the right to file a brief with the commission, which pretty much would summarize your position relative to the complaint. And if you think you need to do that and we don't require it, we probably would like it, and I probably would like it in within the next 10 days. So today is the 4th.
17th.
Pardon me?
It'd be the 17th. It's 10 days.
17th, yeah. The 17th would work. But again, you don't have to, and if you do, then you should share with each other, you know, copy each other in on your briefs. Any questions? Okay, with that, I'm going to close the hearing. I thank everybody for being here and presenting their case. And the time is 4 minutes to 2, so we went over about an hour than we normally would, but I did want to give all parties the opportunity to fairly present their case. And I think we've done that. I think we've got a pretty good understanding of what's before us, so thank you.
Thank you.